Well, he seemed almost offended by certain questions, and claimed he doesn't care who's rich or poor, that there's no such thing as a Republican justice or a Democratic justice. That seems specious, because when you look then at the actual record, so maybe let's look at some actual examples. Mm-hmm. One thing that folks are really concerned about is that Gorsuch seems to believe corporations are people.
That's 100% correct. He was on the original Hobby Lobby case. This is the case regarding whether for-profit corporations have a right under healthcare law to deny critical reproductive health care and access to contraceptives to their women employees. It was a remarkable decision that really was counter to 200 years of legal tradition and analysis. I think one of the senators pointed out to Neil Gorsuch that he calls himself an originalist, but nowhere in the Federalist Papers does it say that the founders intended for-profit corporations to enjoy the same rights as the American people. And what's particularly troubling in that is not just that he held that for-profit corporations are people with legal rights, but that those rights trump the rights of everyday Americans. Nowhere in his decision in Hobby Lobby does he talk about even the need to balance the interests of the women who rely on employer-sponsored health care. It was a callous decision. It was not legally right. And it just demonstrates how results-oriented he is. Let me give you one more example in that context, and that's the case of Planned Parenthood versus Utah. This was a case where the Republican governor of Utah unilaterally decided, after the false videos came out regarding Planned Parenthood, to unilaterally defund Planned Parenthood in Utah, hurting thousands of women who rely on the organization for critical access to health care. Planned Parenthood sued, and judges on the 10th Circuit Court of Appeals rightly decided that they were entitled to a preliminary injunction blocking the governor's unilateral action. And Neil Gorsuch, on his own, without the state of Utah even appealing, sought the en banc review, full court review of that 10th Circuit panel decision. He lost. The majority of judges on the 10th Circuit rightly recognized that the preliminary injunction was proper. Another judge on the panel, characterizing Judge Gorsuch's opinion in that case, pointed out, and these are the judge's words, that he misrepresented the facts in the law in that case numerous times, in his opinion. Again, just a results-oriented approach designed to shield the unilateral actions of a Republican governor to take away critical health care for women.
Well, I did want to ask you about the question of people with disabilities, because that's one where we've seen something very interesting in this week. Gorsuch wrote, of course, the opinion for this 2008 decision that rejected the claim that a Colorado school district wasn't doing enough to educate an autistic student. Now, the Supreme Court, even during his hearings, has come out and said that that is not correct, and in fact has kind of, smacked at the 10th Circuit for that decision. Can you tell us what Gorsuch's role was there and what it means?
Well, they had a really awful set of facts. The case was involving a child by the name of Luke P. And if you have a chance, his father testified earlier today before the Senate Judiciary Committee and could not have been more powerful in demonstrating the steps that Neil Gorsuch took to undermine the educational opportunities for this child. Luke P. had autism. It was undisputed that he was not getting the education he needed and was entitled under the IDEA to a free and appropriate, meaningful education. The facts demonstrated that he was only meeting 25% of his goals, his educational goals in the school. And he rightly exercised his rights under an act of Congress, the IDEA, to demand that the school district do more to properly educate his child. And Neil Gorsuch, in his opinion, rejected Luke P.'s claim. And in doing so, the standard he created, which appears nowhere in law, nowhere in the statute, nowhere in prior Supreme Court precedent, nowhere in prior 10th Circuit precedent, is that Luke P. was only entitled to merely de minimis education. Taking it out of the disability context, I think any parent would be outraged if they are told that a school is only teaching their child 25% of his goals, and that child is only entitled to merely more than a de minimis education. That is not the equal opportunity that the Congress set forth in the IDEA. It demonstrated Neil Gorsuch's callousness to the situation Luke P. found himself in. It demonstrated Neil Gorsuch's contempt for the efforts of Congress to ensure equal opportunity for all persons, including those with disability. And as you alluded to, in another case involving the 10th Circuit, which had adopted Neil Gorsuch's standard, the Supreme Court just yesterday, unanimously, every single judge on the Supreme Court, Democratic appointed and Republican appointed alike, eviscerated Neil Gorsuch's standard and made clear that that was not the intent of Congress, and merely de minimis education is the same as no education at all. I've never seen anything like it where the Supreme Court unanimously demonstrates on the same day the nominee is testifying how unqualified this nominee is to be on the Supreme Court.